All right, let's get this show going. What a beautiful way to start out our Wednesday. Good morning, everyone. Welcome to our Lunchtime Learning Extended Edition. Thank you so much for being here and for sharing this training with others. We have a great half day of presentations that I am so excited to share with you. If you will be requesting CLE credit, I will put the course code in the chat. It is 790489. This session is being recorded and will be made available along with the slides at stopRED.org. While you are there, be sure to check out our Making Connections blog that is posted each month by our RED consultant, Dr. Simmons. Also, if you are not a member of MJJA, consider becoming one to not only support MJJA's mission to promote justice for children, youth, and families, but to support youth and families in your own communities. Check out more info on becoming a member at mjja.org. Also consider getting a team together and joining us for our Teeing Off for Kids golf tournament on September 18th at Eagle Knoll Golf Course. More information can be found at mjja.org. Please mute yourself unless you're asking a question. Feel free to ask questions throughout the presentation by using the chat box, unmuting yourself, or using the raise hand emoji. I want to take the time to thank our funding source. Funds are made available for this project through the Missouri Department of Public Safety and the Missouri Juvenile Justice Advisory Group from funding provided by the U.S. Department of Justice, Office of Juvenile Justice and Delinquency Prevention. And now I introduce to you our first presenters of the day, Hedgie Kim and Patrick Helling. Hedgie Kim is a senior youth defense counsel at the Galt Center, where she works to strengthen youth rights by upholding the fundamental right to counsel for all youth who come into contact with the juvenile legal system. Hedgie dreams of one day living in a world where all children are free to thrive in communities of care and is driven by the belief that our humanity is interdependent, that in the words of Desmond Tutu, my humanity is caught up, is inextricably bound up in yours. Hedgie's work focuses on probation and system transformation as she works alongside the youth defense community to transform systems of harm and punishment from the inside. Hedgie first worked as a fellow at the Galt Center, followed by the Legal Aid Society in New York City, where she represented children and youth caught between the family regulation and delinquency systems. Hedgie returned to the Galt Center in 2022 and finds joy being in community with youth defenders to uphold and strengthen youth rights together. Hedgie graduated cum laude from the University of Pennsylvania Law School and summa cum laude from the George Washington University. Hedgie is a lifelong student of emergence, wholeness, and interdependence. We also have Patrick Helling. He is the Director of Legal Services at the Migrant and Immigrant Community Action Project. He has experience in both juvenile and immigration law. Patrick started his career path in 2010, where he joined the Peace Corps, Honduras, as a youth development volunteer. Patrick's Peace Corps experience inspired him to become an immigration attorney, and he graduated from St. Louis University School of Law in 2015. Patrick then began working at the Florence Immigrant and Refugee Rights Project in Arizona, where he specialized in representing unaccompanied minors in federal immigration custody. After returning to Missouri, Patrick worked at the Department of Social Services Children's Division, where he advocated for children in foster care to find a safe home. He has been with the MICA project since 2021 and continues to defend children facing deportation. And with that, I will turn it over to Ms. Hedgie Kim.
All right, thank you so much, Liz. So I just shared my screen. So hi, everyone. As Liz mentioned, my name is Hedgie Kim. I work at the Galt Center, and I am thrilled to be here with you all today, as well as with my co-presenter, Patrick Helling, to talk about the ways that we can support immigrant youth in juvenile court during this time. So as we get started, I see a couple people have done some hellos in the chat, but we would love to see who's joining us. So if you don't mind just dropping in the chat your name, your role, and where you're joining us from, that would be lovely. So as you're introducing in the chat, let me just share a little bit about the Galt Center. So the Galt Center is a national organization that focuses on upholding the constitutional right to counsel for young people in juvenile court. So we offer training, technical assistance, and resources for juvenile court practitioners. And importantly, we try our best to work collectively and relationally across all areas that impact young people in juvenile court. And on a more personal note, as Liz mentioned, I approach this work as someone who practiced as a frontline defender myself. I worked in New York City, working with dually involved youth. And this training today is one that is particularly meaningful to me based on also my personal identity as an immigrant myself. So I appreciate the time that everyone took out of your day to talk about the ways that we can support immigrant youth and immigrant communities during this time. So thank you so much for being here. With that, let me talk a little bit about what we have in store for today. First, we're going to share a little bit about what youth defense advocates have shared with us over the past year in terms of what they're seeing and the changes that they're seeing in juvenile courts across the country related to immigration. Then we'll cover some opportunities that each of us have in our respective roles to support immigrant youth during this time. And we'll also offer some key resources that you can integrate into your practice. And then I will pass it to Patrick to provide an overview of the immigration relief options that are available for young people to keep on your radar. All right, so thank you all for introducing yourselves in the chat. As we kind of go into the current immigration landscape, I'm also going to ask everyone to share in the chat now what you've been seeing in your jurisdiction related to immigration and young people in juvenile court. So what trends have you been noticing? What practices have changed for you all in the past year or so? We're going to be offering some high-level trends just from a national perspective, but as you all know, this is such a rapidly evolving landscape, and it's something that just varies by state, and then by county, and then even by courthouse, right? So we'd just love to hear from you all what you are seeing locally in your jurisdiction as well, related to immigration in juvenile court. Okay, so I hope it'll start adding some things in the chat that I'll start sharing at a national level, just some general trends that we've been hearing about. The first pattern that we've just been seeing across the country is just that there's been an increase in immigration enforcement presence. And we're talking about in areas that impact young people in juvenile court, right? So courthouses as well as juvenile facilities. And we've also just been hearing more about some increased cooperation between the juvenile facilities and ICE. Another thing that we've been hearing about is that youth and families are expressing increased fear in coming to court or going to programs. And again, this is just due to the heightened surveillance and ramped up deportation efforts that we've been seeing. And as you can imagine, this is going to impact non-citizen youth as well as youth living in mixed status families a little bit more. And relatedly, we've also been hearing about just some community programs and services increasingly asking for documentation. And this makes it, of course, more difficult for non-citizen youth to comply with court requirements to complete programs and services. And lastly, we've just been seeing a wide spectrum of cooperation happening between various people working in juvenile courts and immigration enforcement across the country. And I see Cameron Johnson also said in some counties, youth with proceedings in juvenile court are being arrested by ICE after appearing at court hearings in the parking lots. Yeah, so that's something that we've been seeing and hearing about as well across the country. So please feel free to add a little bit more if you all don't mind sharing. But all in all, what these trends reveal is in essence just an unpredictable landscape, right? That's putting just a lot of heightened stress and anxiety on immigrant children and families during this time. And it just highlights why today's conversation is so important because all of us working in the juvenile court system, we all have an important opportunity and frankly, a very critical touch point to offer support and care to immigrant youth during this time. So with that, I'm just going to cover some concrete ways that we can support immigrant youth that's specific to our respective roles. So the Galt Center has a page with curated resources for youth defenders, judges, probation officers working with immigrant youth. I'm going to drop a link to that page in the chat here so you all have it. So you'll see resources are broken down by role, but we also have a sidebar that includes community resources, links to other organizations with immigration expertise to have on your radar, as well as just some couple directories of immigration attorneys as reference. So what I'm going to do today is I'm just going to offer some sampling of some resources that are on our training page, as well as some key takeaways. And every resource that I'm going to talk about, it can be found on the training page as well. So first, let's talk about youth defenders. So youth defenders are um, very uniquely situated because youth defenders not only have that legal and ethical duty to advise clients of immigration consequences, of course, under Padilla, but youth defenders at times may be the only person or the only adult that non-citizen youth may feel safe sharing their immigration status with, right? And that's because of the attorney-client confidentiality protections that exist within that relationship. So defenders have a really important opportunity to really support immigrant youth during this time. So we at the Galt Center, we have many practice guides and tip sheets and virtual appearance checklists that offer support for youth defenders. And I'm just going to pull out some key high-level takeaways, but these tip sheets that are on our training page kind of tease these out a lot more in detail. So first, is the importance for youth defenders just to screen all your cases for special immigrant juvenile status, immigrant status, and connecting with an immigration attorney at the start of a case. So we have a tip sheet, it's the light green one available, that outlines specific considerations for defenders to think about when considering special immigrant juvenile status eligibility, as well as some interview questions and interview suggestions to be asking your clients as well. We also have outlined advocating for virtual programming and check-ins, of course, when desired by your client. And this is to reduce client anxiety about potential exposure to immigration enforcement. Relatedly, filing motions to seal client records to protect confidentiality, especially given just the information sharing, the increased information sharing that we're seeing across the country. And also keeping up to date on the evolving immigration landscape, right? Especially regarding potential immigration consequences for things that may come up in a juvenile court case. And these are stay away violations and offenses related to drugs, gangs, sex, and prostitution, all of which raise risks of deportation or inadmissibility for non-citizen youth. And lastly, of course, advising clients about the impact of potential immigration consequences and just the implications of that throughout. So on that note, the Galt Center is actually going to be hosting a national Q&A tomorrow featuring two immigration experts. It's available for defenders just to keep up to date on the evolving immigration landscape. So I just dropped a link to register for that in the chat for those who may be interested. So that can just help consider how things are changing right now and what updated considerations that defenders should have in advising clients in this moment. All right. So next, let's talk about judges. So judges have a very unique opportunity to support immigrant youth. We have a tip sheet here, also available on the training page. And we're going to just cover some key takeaways from this tip sheet. So judges, right, have the power to create equal and safe access to the courtroom. This is just a fundamental tenet of due process, right? And when it comes to ensuring safe and equal access to the courtroom, a couple considerations. One, when it comes to ICE presence in the courthouse, it's just to be aware of ICE's policy on civil immigration enforcement in or near courtrooms. So ICE has a policy on this, and under this policy, immigration enforcement generally is not allowed in courthouses that handle non-criminal matters, such as family or juvenile court matters. So under this policy, again, this is an ICE policy, if ICE believes that enforcement is, quote, operationally necessary in a courthouse handling juvenile matters, then they have to obtain supervisory approval. So, what this means for juvenile court judges and court staff is that if you see ICE in or near your courtroom and you handle non-criminal matters, then one thing you can do that's within your power is to ensure that ICE agents are at least complying with their own policy by checking if they have supervisory approval before they carry out any type of immigration enforcement action in your courthouse. So this tip sheet just includes a little bit more guidance and some sample letters that you can take a look at to be able to confirm whether that supervisory approval exists. So, relatedly, on this note, another way just to ensure safe and equitable access to the court system for everyone is just to grant requests made by defense counsel or consider them very carefully to proceed virtually. So again, as I stated, many defenders are hearing from their clients that they or their family members are just fearful of coming to court right now. And allowing for virtual proceedings is just an alternative way that judges can uphold access to courts and due process for immigrant youth. And second, I just want to cover just two considerations regarding court. Um, okay, so before I move on, I see Tiffany's question regarding ICE not being allowed in the courthouse. So, right. So this is going to depend on your state's jurisdiction on whether delinquency matters are considered non-criminal. And I think my colleague Sarah Johnson is also here on this call, and Sarah practiced in Missouri and shared a case with me called State v. Herald. I'll drop a citation here. And that actually outlines very specifically, it's a Supreme Court Missouri case that juvenile cases, delinquency cases, are not considered criminal prosecution and instead are civil in nature. So, it depends on the state interpretation and how your state handles. But under that framework, that legal framework, delinquency matters would be considered civil and therefore a non-criminal matter for purposes of this ICE policy. But I would also suggest in this tip sheet, you'll see more guidance around just the nuances of that in relation to the ICE policy as well. All right, so next I want to talk a little bit about okay, so under when considering court decisions and court orders, just some takeaways that are also outlined in this tip sheet is one, consider issuing short orders instead of orders of protection when you're issuing it against a non-citizen youth. And this is because orders of protection are automatically uploaded into an FBI database that are automatically shared with ICE. So just to be aware of that, right? Of just the negative unintended immigration consequences that may exist through an OP versus a short order that you may be able to issue as well. And then also just considering the fear of travel that many non-citizen and immigrant youth, when you're considering your release conditions as well as your probation conditions. Right, this could look like just limiting the number of conditions that reduce extensive travel or regular travel, such as drug testing or in-person programming, and instead allowing for more opportunities that allow for virtual supervision. And lastly, I just want to note here, although Patrick's going to go into this in more detail, that juvenile court judges are also very uniquely situated to create a passageway for legal status for young people through issuing a predicate order for special immigrant juvenile status. So I just wanted to preview that here, and Patrick will go into the mechanics of that a little bit more, but it's just a really critical opportunity that juvenile court judges have. Okay, so next let's talk about probation officers. So here's our tip sheet as well as a desktop checklist version that we also have available on our training page. This is available specifically tailored for probation officers. So this tip sheet, right, leans into the opportunity that probation officers have to really protect the promise of adolescence while ensuring community safety. And this is across the board, right? It's aligned with the principles of the American Probation and Parole Association, which specifically call out probation to operate based on the understanding that success and healthy development of young people is ultimately what protects public safety. So I'm just going to highlight a few tips and takeaways from this tip sheet. First, you may all have seen this on the news as well, but there have been just some documented events of impersonation attempts to scare immigrant communities during this time, right? So there have been private citizens impersonating ICE to prey on vulnerable communities, sadly. And there was actually a case out in California where an ICE officer impersonated a probation officer to gain unlawful entry into a home to execute an unlawful arrest, which the federal district court held was in violation of the Fourth Amendment. So now, what this means for probation officers is that knowing that this type of tactic is unfortunately something that's happening, um, this can cause generalized anxiety, like, right? Like young people are unsure, like who to trust, what's happening. So when you're first meeting a young person, it may be helpful just to outline up front how and when you'll be checking in with them, right? And that's just is going to give a little bit more clarity for the young person to better protect themselves against any type of impersonation attempts that they may be worried about. Also consider in that meeting sharing some Know Your Rights materials with young people. So on our training page, you'll see a section for youth and community members, and we have some key Know Your Rights materials there that you can print and or just share a link with the young people that you work with. Probation, there are very few opportunities, if you think about it, for a non-citizen youth to come across an adult who cares enough to share some key Know Your Rights materials, and probation officers are just an important touch point for young people. So I recommend taking a look. One that is the most widely used are the red cards by the Immigrant Legal Resource Center. We also have a link to that in our training page as well. And again, this is an ongoing theme, but given just this heightened fear that youth and families are experiencing, allow for virtual reporting and check-ins for young people, or alternatively, meeting youth in safe spaces that they've identified in their communities. Um, so another trend that we've been hearing about, as I stated, is the information sharing practices by courts, probation, and facility staff with ICE across the country. So the legality of this practice is just going to vary by jurisdiction, right? But what's important for immigrant youth is just transparency right now. So to the extent possible, I think it's important to be aware of your department's information sharing practices. And then just to be upfront and honest with young people so that they can make an informed decision about what's safe to share and what's not safe to share. And it's just that transparency offers a young person some dignity in their decision-making choices, and to be aware of the consequences of the information that they may be sharing with you. Relatedly, what this also means is really examining probation conditions that are being recommended during this time, right? Now more than ever, it is important for these conditions to be tailored to the unique needs and circumstances of youth. Again, taking into consideration the fear and anxieties around travel that young people and their families are experiencing right now. And then, of course, on the back end, if a young person doesn't fully complete your probation conditions or they're missing some check-ins with you, consider first having a conversation with the youth to better understand what's happening in their lives. And then, as much as possible, utilizing administrative reviews instead of or accommodating and modifying the probation conditions to accommodate with what's happening in their life, as opposed to jumping to detention or revocation recommendations, which of course can also have unintended immigration consequences for young people. So this is all ultimately in recognition that young people and immigrant youth especially are under a lot of stress and heightened trauma right now. So we all as juvenile court practitioners or as people who are touching the system in various ways, we all have a very unique opportunity to offer support to guide young people's healthy development as opposed to creating barriers that may unintentionally harm young people and their families. So lastly, I just want to highlight a few national resources here that may be worth having on your radar, regardless of what your role is. So I'm going to drop a link to this in the chat so you have that as well. The first is just really quickly is a national living Google Doc of various rapid response networks. So you'll see in Missouri, the St. Louis Rapid Response Coalition is listed. They offer legal resources, detention, and emergency assistance for immigrant communities. The second is a living map for mutual aid. So Missouri has a couple spots for mutual aid as well as offering basic necessities and support for really anyone, but also including non-citizen youth. The third is a legal hotline. It's designed for young people who want assistance finding and obtaining identification documents. As you all know, it could be very confusing and cumbersome to try to obtain. So this is a hotline that's run by the National Network for Youth, as well as Baker McKenzie's pro bono department. So they'll work with young people, they'll work with non-citizen youth specifically, as well as homeless youth and other youth interested. And the fourth is a link to a directory of nonprofit immigration legal services, right? So right now there's a dearth of immigration attorneys. So this is just a helpful starting place to take a look in case you need to consult and refer a case. And of course, I think Patrick will talk a little bit more about Missouri specific organizations as well. And lastly, United We Dream is a beautiful organization. It's a youth-led immigrant network organization that offers lots of youth-friendly organizations and engagement opportunities. So it's just a good one to keep on your radar in case you have a young person who may be interested in being connected with their network. All right, so that's all from me. Here's my email address in case anyone is interested in discussing further. And with that, I will now pass it to Patrick.
Okay, good morning, everyone. Thank you all for being here. I'm going to share my screen here. Okay, so again, my name is Patrick Helling. I'm the Director of Legal Services at the Migrant Immigrant Community Action Project in St. Louis. Just a little bit about us and what our work is we're a nonprofit legal service provider providing immigration representation for a wide variety of cases. I myself spend a lot of time working on deportation defense, defending children in deportation or removal proceedings, but also affirmative applications with USCIS. And as I'm going to talk about, I do spend quite a bit of time in state court working on predicate orders as part of special immigrant juvenile status cases. So with that, I'll go ahead and get started. So the first thing that I want to convey to everyone is that I think the public has a misunderstanding that we have a much more generous immigration system, and that more people are eligible for some sort of legal status that actually are. I think there's a misunderstanding out there that there's this imaginary line where if someone were just to leave the country, get in line, dot all their I's, cross all their T's, then they can come back. But in reality, that's not the case. There are a very narrow set of pathways for individuals here in the United States. And if they're not eligible for one of those narrow pathways, there's not some line out there that they could get into in order to come back. The purpose of what I want to talk about today is you all in your work, if you come across a non-citizen youth, and you think they might be eligible for some sort of legal status, hopefully you might be able to identify that and then help them get connected with an immigration attorney who could assist them in their immigration process. So the first one that I'm going to talk about is special immigrant juvenile status, which I imagine a lot of you have heard of. And then I'll spend a good portion of our time talking about T's and U's. And then at the end, we'll briefly talk about asylum and family-based petitions. So to begin, what special immigrant juvenile status, what is it? It's a humanitarian protection for abused, abandoned, or neglected children here in the United States. And it provides a pathway for them to become lawful permanent residents or legal permanent residents, and then eventually United States citizens. It's a three-step process, and it's a lengthy process from start of the case up until someone is a green card holder or an LPR. It could take 5, 6, 7 years. It is a long process. But the first one, and what I'm going to spend the most amount of my time talking about today, is obtaining a state court order. Sometimes you'll hear practitioners refer to it as the predicate order. And that's where you need to get the specific findings that the child was abused, abandoned, or neglected by one or both parents, and then some other findings that I'll talk about in the upcoming slides. And this is a federal petition that you'll be filing. So why state courts? Why does the law require state court findings? Well, when Congress was creating this and saw this need for this type of protection, they recognized that the juvenile courts, family courts, probate courts were all the purviews of the states, and they were the experts in child welfare law, juvenile law. And that really wasn't the federal government's domain. So, like I said, I'm an immigration attorney who spends a lot of time in state court. Then once you get that predicate order, then you file Form I-360, Petition for Special Immigrant Juvenile Status, and you send that off to United States Citizenship and Immigration Services. That is under the Department of Homeland Security, and it is the agency that processes affirmative applications. Then once that application is approved, you still have to wait for a visa to be available for you. This is the part that can take a long time. So right now, in June of this year, USCIS is processing applications or receiving applications for those who filed Step 2 in June of 2022. So it's from start to being able to actually file Step 3. Right now, it's about 4 years. But then you still have to wait for your I-485 to be approved. That's your application to become a permanent resident. You might hear it referred to as adjustment of status. But then after that third step is approved, then the person is a green card holder, legal permanent resident. So these are the three main findings that you need in that predicate order, in the state court order. And what I've cited to here is the federal law that has these specific findings. And I'll talk about this more in depth later. But when crafting predicate orders, it's really important that you're not making citations to federal law. This is all that what the judges are signing off on is consistent with their authority under state law. These are just the eligibility requirements that Congress laid out. So the first one is that the child is dependent on a juvenile court or legally committed to or placed under the custody of a state agency or an individual. So that's a kind of a broad range of juvenile cases or cases involving children. It just needs to have a final custody order. So that could be with Children's Division. It could be probate court with a minor guardianship. It could be in a paternity and custody action. It could be in a dissolution action. Any state court that has lawful authority to issue custody orders. It could also include delinquency cases as well. And that there also needs to be a finding that reunification with at least one parent is not viable due to abuse, abandonment, neglect, or a similar basis under state law. And then the last one is that it's not in the child's best interest to return to their home country or country of last habitual residence. So kind of headline eligibility requirements. in order to apply for special immigrant juvenile status, you have to apply before the juvenile turns 21. However, for purposes in Missouri, the state court actually has to have jurisdiction over the child. And so for completing that first step, 18 is a hard deadline. The child cannot be married at least until step two is completed, declared dependent or placed under the custody of an individual or state agency. Reunification is not viable due to abuse, abandonment, or neglect. And again, best interest not to return. So the validity of the state court order. As I said, it has to be a final custody order, a permanent custody order. So temporary powers of attorney or springing guardianships are insufficient. Temporary guardianships. It has to be, like I said, a final order, and any state court that has authority to make custody can make these findings. So again, that's juvenile, family, probate, delinquency. USCIS, when they receive the predicate order, is they are not looking to look behind the submission, look behind the predicate order. And they're not looking to second guess the findings that the state court judge made. However, they do have to provide specific consent, essentially meaning that the predicate order and the petition that led to that was bona fide. And what they mean by bona fide is that what was the primary reason that the state court petition was initiated. And they recognize that there can be some immigration motivation for moving into state court. It just can't be the sole purpose. There actually has to be relief from parental abuse, abandonment, or neglect. And so how do you prove that? It's really important to contain the factual basis for each specific findings. And you can't be citing to just federal law. Really what USCIS is looking for is that this was a case that came under the state court's docket and in the course of ordinary business made these findings. So for example, when you're making the custody order or drafting your predicate orders, it's important that the court explains, well, why? Why did they make the finding that this individual was placed under the custody of that adult or state agency? And then defining the statute for abuse or abandonment or neglect, and how exactly did that happen? What factual findings did the court make when determining that the child had been abused, abandoned, or neglected, and why reunification is not viable? And then the other one that I think sometimes can get kind of tricky is, but not in the best interest to return, is USCIS is kind of looking again, is that was this like a legitimate hearing? Was evidence adduced? Were there specific factual findings? So things that they might be looking for is well, one, back in home country, the child doesn't have a caretaker able to provide for them. But here in the United States, they're living with their legal guardian, their mother or their father, or alternatively, they're in children's division custody and CD is providing services. They're in school, they're receiving counseling to recover from the trauma that they endured. And that if they were to sent back, not only would they be alone, but they would lose access to all of those resources that they currently have. So it's important those predicate orders have the factual basis for their findings. And then you can find all of that at the USCIS policy manual. I think when doing or crafting predicate orders, it's the policy manual is a really good resource because this is USCIS telling you these are the eligibility requirements. These are the things that we want in the predicate orders in order to approve it. So now I want to pivot and talk about T visas. So T visas are for victims of trafficking. And one of the main things I would like to leave you all with is that for the purposes of a T visa and how federal law defines victim of trafficking, it's a lot broader than I think most people realize. A lot of the times people think the trafficking has to involve some sort of movement across a border, whether that's an international border or state borders within the United States. But that's just, it's not the case. Someone could be confined to a singular home, a singular room, and still be eligible for a T visa. Um, Also, what type of work the person was coerced and forced to do is a lot broader as well. And the coercion concept is a lot broader as well. And we'll talk more in depth as we move on. Once your TV's application is approved, you don't become a legal permanent resident automatically. It's a non-immigrant status. You are lawfully admitted into the United States once your case is approved. It lasts for 4 years. You have work authorization, but then you could file for adjustment of status to become a legal permanent resident after 3 years, or if the Department of Justice has determined that the investigation or prosecution is complete. And the other thing that I would like to emphasize is that T visas, and we'll talk about U visas as well, is that those are law enforcement tools. There's a reporting requirement, there's a certification requirement for U visas, and for T visas, the victims are required to cooperate with law enforcement in its investigation or prosecution. So yes, this is a humanitarian form of relief, but it's also to encourage victims to come forward and cooperate with law enforcement. And so this is a tool for them as well. So mainline eligibility requirements. You've been the victim of severe form of human trafficking. You're physically present in the United States on account of the trafficking. Essentially, that just means is that the trafficking happened here in the United States. And then since you were trafficked, you haven't left the United States. There's some exceptions and nuance to that, but really, if someone was recently the victim of trafficking, they're still here, their initial entry doesn't necessarily have to be on account of the trafficking to satisfy that element. And then the victim has to comply with request for assistance or reasonable request for assistance from law enforcement in the investigation or the prosecution. So at minimum, that requires the victim to report what happened to them to some law enforcement entity. There is an exception, though, to that, where if you were under 18 at the time the victim was victimized, then then they don't have to report. And then they would suffer extreme hardship involving unusual and severe harm upon their removal. So there are two types of severe form of trafficking. There's labor trafficking and sex trafficking. And there are three main categories of elements on how you prove that. So first you have the action committed by the trafficker, the purpose, why did they do this, and then the means. How did the trafficker compel or attempt to compel the victim to do some sort of act against their will? So moving into labor trafficking, this is the action part of the category. And I'll note that this is a disjunctive test. So you only need to satisfy one of these elements in order to satisfy the action element. Also, if it happens one time, then you could satisfy that as well. So this is the trafficker recruiting the victim, harboring, transportation, provision, or obtaining. And then I'd like to spend a little bit of time talking about harboring. Essentially, what that means is that the perpetrator is taking steps to exert control, reduce access, and essentially limit the agency of the victim. So if the trafficker were to say, for example, to take the victim's way to communicate with the outside world, phone, internet, keeping the person in a home, isolation, controlling access, restricting movement. That's what you're looking for in harboring to prove a T visa case. And then for transportation, say, for example, if the trafficker is taking the victim to work, then they have transported the victim. and you've satisfied that element. So the means, how did the trafficker force the person or the victim to do this sort of labor? So there's force, which, physical force, which is what that sounds like, fraud. And then I think the broadest one and where I think kind of the most important one is coercion. And what you're looking for in a coercion case is it's a totality of the circumstances test, where it really is would a victim or would an individual in the victim's circumstances reasonably feel compelled to comply with the trafficker's demand. So, for example, if you're working with a juvenile who's 15, 16 years old and hasn't spent much time here in the United States, um, they don't speak English, not familiar with our systems and our laws. Would it be reasonable for them to believe that the trafficker had the ability to act out the threats that they were making? So you're looking at threat. It can be something like threats of serious harm or physical restraint. It is also abuse or threatened abuse of the legal process. So, for example, if a child finds themselves being trafficked and the trafficker is threatening to call ICE or call immigration or call the police, and then they'll call ICE or I'll get you deported. It doesn't really matter whether or not the trafficker has the ability to actually get the victim deported. What really matters is it reasonable for the victim to believe that? Essentially, what you're looking for is to um, was it reasonable to get into the mind of the victim? Why were they doing this labor? Why were they forced to do it? And was it reasonable? And I pulled these examples from the USCIS policy manual on T visas. So these are other examples of coercion. So threats of harm to third persons, banishment or expulsion from the home, bankruptcy of the victim or family members. So if a child is living in an unsafe home and the trafficker is threatening to kick them out of the home or fire them from their work and say, well, you're undocumented, you won't be able to find other work, and so you'll go hungry. You'll starve on the streets. These are the types of things where it could be coercive in nature, where the victim feels like they no longer have agency in whether or not they are going to continue doing this labor. Withholding of pay or compensation. So if someone needs, and now they don't have enough for food, for paying medical bills or debts, subjecting the victim to isolation, denial of sleep, threats of deportation, or to call immigration or other law enforcement, or reputational harm. So again, coercion is broad but really what you're looking at again is why did the victim feel compelled to act? And based off of what was being said to them, was it reasonable? So purpose is this move shifts to the mental state of the trafficker. So why did the trafficker do this? It was subject them to slavery, subject the victim to debt bondage, and then involuntary servitude is the one that really almost mirrors coercion. So if, say, for example, a trafficker or someone is victimizing a child, that in and of itself doesn't make a trafficking case. You need the mental state of the trafficker saying, I'm doing this in order to compel some sort of labor. The trafficker wants to subject the victim to involuntary servitude, which describes the state of being that the victim finds themselves in. Here's some more thoughts on involuntary servitude. So the trafficker holds the victim in servitude by placing them in fear of physical injury, restraint, or other coercion, and then therefore the victim decides or is coerced into complying. So if the victim is free to quit work or wherever they are without fear of consequence, then they're not subject to involuntary servitude. Now, this is an important note, though. If someone were to leave the trafficking situation or to escape the trafficking situation, that doesn't necessarily mean that they weren't trafficked. The victim can overcome that fear after being subject to trafficking. Um, Also, attempts to traffic someone can make them eligible for a T visa as well. The other thing that I want to emphasize is that domestic violence and labor trafficking frequently overlap. The labor that is required in a T visa case isn't traditional work, or it doesn't have to be. So it's not necessarily someone was forced to work at a business. It could be someone was forced to do domestic labor. Someone was forced to do childcare. Someone was forced to do elder care. Someone was coerced into a sexual act. All of that can make a labor trafficking case. But again, abuse or mistreatment alone is insufficient to prove a trafficking case. What you're looking for is abuse or mistreatment used to compel labor or services. So sex trafficking is a little different. You still have the recruitment, harboring, transportation, the action, and then the purpose, though, that is what's different, is that it has to be for the purpose of a commercial sex act, and we'll define that in the next slides. And the sex act was induced by force, fraud, or coercion, unless the victim is under 18. So how does the federal law define a commercial sex act? It's when anything of value is given or received by any person in exchange for the sex act. Note that it's an or test, not an and test, and anything of value. So it doesn't have to be money. It could be housing, it could be food, it could be drugs. And again, the victim doesn't have to be involved in the things of value being exchanged. So the victim doesn't have to receive anything in order for it to qualify as a commercial sex act. So shifting gears to U visas. U visas are for victims of qualifying criminal activity that possess information about the qualifying crime, and they have been or likely to be helpful with law enforcement or the prosecution or a judge or any authority investigating the criminal activity, unless the child is under 16, and then someone else can be helpful on their behalf. And then as a result of being the victim of qualifying criminal activity, they suffered substantial physical or mental abuse. So the U visa, similar to a T visa, is a humanitarian form of protection for victims of crime, but this is also a law enforcement tool. Unlike the T visa, where you just have to comply with request for assistance, U visas actually require a certification from the entity that is prosecuting or investigating the criminal activity. And without that certification from that entity, you cannot file a U visa. It's a prerequisite. So talking about the certification from law enforcement, that's the Form 918BU. The certifier does not necessarily have to be related to the criminal justice system. So for example, the proper person at Children's Division could certify that the victim was the victim of that crime and was helpful in Children's Division's investigation. The juvenile office could sign one of these. Federal judges, state judges, local judges. It could be family court. It could be orders of protection. The judge that hears the order of protection, they could sign this certification form. It's T visas have a certification, but it's not required for T visas, but for U visas, it is. The other thing that is important to know is that if the certifier were to sign off that this happened or sign off on the certification, it's not a criminal finding. Federal Department of Labor could sign off on this. State Department of Labor could sign off on this. Again, Children's Division. And it doesn't require a judicial finding. So, for example, the chief of police for a local police department could sign off on a U visa certification, but not actually pursue charges. The Children's Division, POE finding, orders of protection, juvenile judge after adjudication hearing. So I pulled these from the statute. These are just examples of the different types of qualifying criminal activity that can make someone eligible for a U visa. Domestic violence, rape, felonious assault, sexual assault, blackmail, witness tampering, stalking, kidnapping, but also attempt to commit any of the named crimes. You could find an exhaustive list at the statute that I listed there if you're interested. Now, sometimes the federal crime listed doesn't neatly overlap with exactly how it's defined at the state level, and that's okay. If the federal statute doesn't equal the state statute, the regs there talk about how it just has to be similar activity, and the elements have to be similar. So it doesn't have to be a perfect one-for-one match in order for it to fit one of the criminal offenses listed above. Moving on to asylum. This is the jurisprudence around asylum has changed a lot in the last 18 months. So a lot of these particular social groups that I'll talk about are subject to a lot of litigation right now, and a lot of that is in flux. I just wanted to put a pin in that. But in short, what you're looking for in eligibility for asylum is that you have a well-founded fear of persecution in your home country because of your race, religion, political opinion, nationality, or membership in a particular social group, and that the government is unable or unwilling to protect you. So in those cases, I think a lot of times people think that they came from a dangerous place, and therefore they experienced harm, and then therefore they're eligible for asylum. But that's not really the case with asylum law. The persecutor in asylum law has to be motivated to harm you because of your protected characteristic, because of your protected ground. So the mental state or the nexus of the persecutor is really important. You not only have to have that protected characteristic, you have to be actually the persecutor wants to harm you because of that. So examples of traditionally valid particular social groups, and again, a lot of this is in flux and subject to litigation right now, but children viewed as property and unable to leave that relationship historically has been a valid particular social group. Family membership, if you are harmed because of your family membership, indigenous heritage. So if you speak, say, for example, like a Mayan dialect in southern Mexico or Guatemala and were harmed because of that, women's and girls viewed as property and unable to leave. And it just kind of briefly, when you're looking at a particular social group analysis, in order to be a member of a particular social group, the social group has some sort of immutable characteristic that they can't change about themselves, and also that the members of that particular social group are defined with particularity, where essentially what that means is that there's clear borders on who's in this group and who's not. And then lastly, is this group socially distinct? And what that means is this group uniquely vulnerable in the country at question? And are they held out different or treated different than the rest of society at large? And then lastly, family-based petitions, children's United States citizens, children's of legal permanent residents, siblings of United States citizens and LPRs don't really have much value because the processing times and the wait times for those visas are just, I'd be so long. I mean, like 20 years that there aren't really a viable option. Um, Questions?
So there was a question in the chat um, from Nigel.
Yes.
Okay.
Um, so if one parent, so I think it's important to remember is that you only need um, abuse, abandonment, or neglect with one parent. You don't need to make that finding for both parents. Um, and when it's the child's best interest to return, again, that's like a disjunctive test. And so you could say that it's not in the child's best interest to return to the child's country of nationality or last habitual residence. And so I think you could probably craft your predicate order for the parent that you wouldn't have necessarily need to look into the other country or make a finding that it's not in their best interest to return. The other thing that I think you could do is if that parent has abandoned and the child doesn't have anyone in that country, I think it's fair to assert that they would be alone based on the history of abandonment and their lack of connection to that country. I believe so, yes. The presentations will be delivered. And then the other thing that I wanted to mention that I forgot to do is I'm going to drop a link to the Department of Justice immig immigration court. They have a list of pro bono or low bono um, legal service providers throughout the country. So the Missouri is included in that list. But if you come across children who might be going to a different state, they'll have, yeah, all 50 states are included in that.
Any other questions for either Patrick or Hedgie? Both of your presentations were so full of information and resources. I think people are probably going to take it all back and go through it all. And then if they do have questions, are they welcome to reach out to either of you and get clarification?
Yes, of course. And I will type my email in the chat now.
And I'll do the same. Of course, happy.
Thank you for doing that. I was a little surprised that in the beginning, we only had one person post, current issues that they're seeing or things that they're seeing as far as ICE or in the court system. I assumed, I guess, in the larger cities or the larger circuits that they would be seeing much more activity. Have you seen that it's kind of died down, or not died down, but lessened? I feel like there for a while it was really booming, and then has it decreased? Have you seen that?
So I think what's so hard about that is it's so jurisdiction dependent. So while in some jurisdictions the practice may have slowed down a little bit, in other jurisdictions it's ticked up. So I think in balance, it's hard to say. And frankly, it just varies even by county and city. So But all in all, the generalized fear of it being a possibility is still very resonant among immigrant communities. And again, I think it just comes back to the unpredictability element, right? Like knowing that it could happen again at any time or tick up at any time. I think that's what's causing a lot of the fears around it.
Yeah, and just to second that, kind of just like the jurisdictional specific nature of immigration enforcement right now. I think a lot of people look out their window and don't see Minneapolis in front of them, don't see Chicago in front of them, and think that enforcement's not happening. But there are these things called 287G agreements where state and local law enforcement can. Contract with ICE to do immigration enforcement. And that's really how we've seen immigration enforcement here in Missouri, where there's a police to ICE pipeline for sure. And so, because of the local cooperation, they haven't necessarily needed the big footprint that we saw in other jurisdictions.
That makes sense. I know I've witnessed or heard of a lot of families unenrolling their children from school because of the fear um, that then they would, know where to find those families that may not be um, documented. So that's mainly what I've seen in this area.
Yeah, and we've heard the same as well, just throughout.
Yeah, keeping everybody inside.
And it certainly does appear to be jurisdictional because here in Texas, many of the school administrators have been concerned about ICE being on the outside of the school campuses as the families are dropping their children off or picking them up. And so it's been a major concern, especially in the larger, more urban areas of Texas.
All right. Any other final comments or questions before we take our break? I want to make sure everyone has a chance to be heard. All right. Well, thank you so much for this resourceful presentation from both of you. I know that we've learned a lot, and we're going to take it back and help those in our communities. So we will go ahead and take a break and be back here by 10:30 for Dr. Johnson and Dr. Simmons' presentation.
Thank you so much for having us.
Yeah, thank you all.
Great presentations.